Morning, everyone, and thank you for joining.
Good morning.
Good morning, Mike and Matt.
Good morning,
I'm
Lena.
so glad that you could join us this morning. You know, we haven't had a meeting since February, so this was something that we really needed to do because it had been such a long time since we'd had an HR Connections meeting, and we've had so many things happening on the HR front, especially with COVID-19, and there's a lot of confusion. So I wanted to have Mike and Matt come in and just talk about it and hopefully respond to questions. Now, I just came in. I don't know if Doreen had mentioned that you are able to raise your hand and post any questions, and Mike and Matt will try to take them at the end of the presentation. If not, we will compile answers and email it out to all the participants today.
Yeah.
So we can at least make sure.
And I'm also, Lena, I'm also recording.
Okay.
So, you know, I can.
Anyone who wants to, they can come.
We can figure out how to make that available to anyone who may want the recording. And you can also save the chat. There are three little dots on the chat. And if you want to save the chat to your file, you can do that. If that doesn't work, I always have the chat. It always gets saved. So you can email me and I can send it.
Do you want them to put the questions on the chat?
No, Mike and I spoke about it. And what he's going to do is after each section, he's going to have a Q&A and people can unmute themselves. I'm going to mute everyone in the beginning. And when he starts to speak, and then they can unmute themselves and ask their question and then put themselves on mute again. Okay?
That's
all
good.
Right. So.
All right. Well, I'm going to, again, introduce Mike Hekle. You've all seen him before in the past. Mike is always very generous, and this is the 7th year. He has been with us from the very, very beginning. And every June, he would normally come in and do our legal update for the HR group. So, Mike, I really appreciate your generosity and the time that you take out of your busy schedule. I can never get this gentleman on the phone. So I know he's always busy. So it is a big sacrifice for him to come on. And I really, really do appreciate it, as does Liz. And then just to let you know, Mike has been with Jackson Lewis. I've actually known Mike since he joined Jackson Lewis many, many years ago. He is a partner with them now. He has been for, what, about 7, 8 years now, Mike?
We're going to date ourselves, but it's probably been double digits now.
Okay.
So with the firm, my 19th anniversary was last week. Yeah.
So I thank you for coming here and speaking with us about it. And Matt, I'm just going to, I don't believe I've met you before, Matt. So I'm going to just very quickly read Matt's bio. He is an associate in White Plains at the Jackson Lewis office. And his practice focuses on representing employers in a wide range of labor and employment matters, including preventive advice and counseling. And I would like to welcome Matt as well to our group. And with that, I'd like to hand it off to Mike.
Okay, Mike, just give me a moment to mute all, okay, and I'll unmute you. And also, if you like to just see the speaker rather than seeing everyone, you can just put it on speaker view, which depending on your device, you'll see it somewhere. Okay, here we go. Hold on a moment.
God bless you if you just want to see me. Okay. See if I can.
Okay, Mike, I think you're ready to go.
Okay, let's see if we can get this program up here. I think I got it. All right.
Looks good.
Okay, so first of all, thank you, Doreen and Lena and Liz for having Matt and I. I can't believe it's been 7 years since we've been doing this. Time is really flies by. I guess, you know, a few things that I just want to touch upon to give everyone a little bit of a sense of what we wanted to accomplish today with the group. Matt and I are going to go through a host of different topics that are related but unrelated. You know, Lena, it's interesting as a group that you haven't had a chance to meet, and I know some other groups that I work with have been in the same predicament, and to say it's been a challenging or interesting time, and interesting can be a negative certainly, is an understatement. So I've had the misfortune of doing a few of these what I would call pandemic programs. And what I find, and I'm sure with this group, because I know you fairly well, at least some of you, you probably know as much as we do. And, you know, our goal today, I think over the last 7 months, and Matt and I have worked pretty closely over that window of time, is we've tried to help different organizations and employers with problem solving more than what the law is. I think we've always sort of tried to pride ourselves, and I think, and this isn't a Jackson Lewis plug, I think most firms that do what we do, you know, if we're good at what we do, we try to problem solve, because the answer isn't necessarily in the law. And quite frankly, and you'll see this today, because we'll talk a little bit about, I think Matt has it on his plate a little bit, the New York paid sick leave, is that we're getting this push of legislation at a pace that is, well, certainly is unprecedented. And I think most organizations are struggling to incorporate it within their policies and practices. And I think back to March when, you know, the lockdown first began and the onset of the virus took hold. And there was the passing of the CARES Act in late March and early April. And what were we going to do? What were we going to do with the FFCRA and the enhanced FMLA, and how were we going to implement it? And we had a lot more questions than answers, and there are still some holes in these laws, even though they've now been around for many months. So it does lead us to trying to kind of put our fingers in the dam and hold the water off more than to have concrete answers. But we'll go through that today. And what Matt and I are going to do is, as we go through the program, we're gonna go through these 6 topics. So we certainly want to talk about the leave, although for many of you, if not all, it's probably something both on a state and federal level that you're already well adverse or well initiated to and possibly even somewhat comfortable with. But we'll talk about that and how to process those leaves and different considerations. As probably all of you know, New York State has passed, as if we didn't have enough going on, a paid sick leave law. So Matt's going to touch upon that. And then there's a couple of semi-related topics that we find come up quite a bit. I've certainly dealt with more unemployment questions in the last, 6 months or so than I have probably in the last 6 years. So I want to give a sense of some considerations related to that and related to changing in your staffing order, and also expense reimbursement and considerations you have with a remote workforce, which maybe some of you or many of you have still working remotely as we try to bring staff back into the workplace. And I know many groups are now looking at those reopening plans, and that's another topic that we didn't necessarily squeeze in today's program, but I'm sure we'll touch upon in some capacity. So I'm gonna start with the Families First Coronavirus Act, and also talk about the quarantine leave law in New York State. And like Doreen had mentioned, what we're going to try and do is, once I get through this topic and before I pass it off to Matt to talk a little bit about the processing of leave requests under these laws, we'll open it up and try and answer any questions. So, you know, the first thing that I think is, and maybe the most important thing about this, is from a federal perspective, the Families First Response Act, it has an expiration to it. And it's important to know that and to plan around that. It is set to expire, at least currently, on December 31st. So we're only a few months away. Most organizations have made decisions regarding whether they, first of all, are exempt under it. And if they are, whether they're choosing the full exemption or the partial exemption, and its application to your workforce. For the most part, though, what I've found with most organizations that are dealing with this law, the troubling part is actually happening right now. And I'm taking these bullets a little bit out of order, and I tend to jump around a lot, so I'll apologize up front. But the law, and I'm sure all of you or most of you already recognize, the law provides different types of leave, and it's really divided into 2 separate laws. Oh, and I see Lena waiting to come in. I think I can admit her. Okay. So the two separate laws, first you have the emergency paid sick leave provisions, and then you have the enhancements to the FMLA. And they're relevant for our purposes and for yours for two different purposes. One is, or two different considerations. One is just who's eligible for these types of leaves, and then the pay provisions under them are slightly different, and you should be aware of that as well. But first of all, it's important to understand who does this apply to. So, the law itself, and I had mentioned the expiration date. I think one thing that'll be important for all of us to keep track of, depending how things play out in November, whether the law is continued, enhanced, or terminated. And, not to make any political commentary, so I'll sort of stop right there. But I do think that depending on how things go, that first Tuesday in November, you may see a continuation of this law in some capacity, or you'll see it sunset with the December 31st date. The law, when it was first enacted, did exclude large employers, which was a bit of a surprise for many groups, but there was that carve out for organizations that are 500 or more. The reason for it was simply that they were, and there's really two components to it. One was the general thought that those organizations were going to be able to take care of their employees anyways. And the second was that under the PPP program, that those that excluded themselves under this CARES Act and this benefit provision may not necessarily then be looking for PPP money, although I don't think that played out the way the government had thought. The law itself does provide for the most part, for public employers to provide this benefit, or these benefits, as they're somewhat distinct. And the exclusion part on an employer by employer basis, there is an exclusion. The most prominent is for emergency responders and those that work in healthcare. There has been some indecision, I'll put it that way, and some challenge to what qualifies and what doesn't. It was a very broad definition that came in through the FAQs in late April, early May, that allowed most health organizations to exclude anyone within their facilities. There was then more recently a Second Circuit decision that rolled that back, and the Department of Labor only about 2 weeks ago now reissued their guidance in this area and only allowed employers, and specifically employees of healthcare providers, who have direct patient contact. So I won't belabor this too much because it may not apply to many, if any, on the phone, but those that are in the healthcare arena should be mindful that this area of that exclusion has changed, and you need to go back, and if you've been excluding yourself from these benefits, to re-examine. The other thing that I just point out here is from a very general sense, the law itself has, and this is the point I was going to make earlier, is really separated into two concepts. It's provided leave and benefits for those that have become sick themselves. And that's really, for the most part, and we're still dealing, obviously, when you follow the numbers, with folks that are that do contract the virus and have need for leave. But what we're really finding right now is, with the opening of schools, or the attempt to open schools, is the child care provisions, and what qualifies, and then what's the entitlement. So we'll jump into that a little bit this morning as well. So the 6 qualifying factors, and I've sort of touched upon them already. Oop, let me go back here, sorry. The first being what we knew really and is most common in the beginning, are those employees that were receiving orders of isolation or quarantine. And in the very beginning, many of you may have realized or witnessed through your own staff where employees were providing notes from local health departments. That did not last very long. I think they became overwhelmed. And as you'll see with the state law, the federal leave laws soon were looking at this in a different way, and healthcare providers and primary care physicians became much more involved in writing these notes, which are recognized really under element 2, where an employee has been advised by their healthcare or their primary care physician if they need to quarantine. Obviously, for the most part, it's been based upon positive tests, but we do have under the federal law where if someone has a compromised immune system, that they may be directed and they would be protected under the federal law, so they would qualify, which is not necessarily the case under the state law. The final sick leave provision is really element 3, where employees are experiencing symptoms but have not been diagnosed. And really the concept behind this component of the law was to let those who are coming in or phoning in the day of and becoming ill, and they're exhibiting symptoms that would align them with COVID, to go get tested. They wanted to encourage testing through this law, and that was a paid leave provision to provide it. As any good intended law, I have seen some employees that have been granted leave under 3 and disappeared for a week and a half. And we've dealt with issues related to that. The concept here is that should be best efforts to get that medical testing. Obviously the swab takes although it's uncomfortable, it takes all of 30 seconds to be done, and the availability now is everywhere. So employees shouldn't be manipulating item 3 for a week-long vacation in any way. So 1, 2, and 3 are pretty simple, I think, for the most part, and we've dealt with it. I think where we're seeing more activity now is really items 4 and 5 within the Families First Act. Item 4 is the caring for an individual who has been directed, typically by their doctor, to quarantine. So pretty simple when it's a family member and they need to care for themselves. It's even more simple when it's a minor. It becomes a little more convoluted when it's a spouse or an adult family member. Does that person require someone to care for them? And I've had a number of calls and worked with a number of employers over that particular issue. The last one I remember was the scenario where a spouse had called and they were an employee of a large service provider, gas service provider in New York State, and they had actually a number of calls, and it was the spouse or significant other that had contracted, and they were going to stay home and care for them. And there was a question of, really, was that necessary? And how do you prove that? And we talked it through, and in some scenarios we felt like it was appropriate, and in some scenarios we actually took the position that it wasn't, and we required the employee to go back to the healthcare provider of their, in this case it happened to be the husband, and identify that they needed a care provider and that they weren't able to quarantine on their own. So, and the doctor refused to provide that. So the leave was actually denied in that scenario. But it's something to look for just as a practice point for all of us. 5, and I'm just going through these individually, if I can stop clicking off the slide on you. So 5's probably, for me, the biggest source of frustration and activity in the last probably month or so is really what to do with schools. And I'm going to open it up when I get to the end. I've got a few more slides just on these 2 leaves, and I'll take whatever questions you have. But there's a lot to unpack here. And you're seeing it depending on the school district, or even within districts, different schools are taking different approaches, which makes it very difficult for families. But you have full-time school being available, you have hybrid, you have remote learning, and how does all of that work? And from a very basic practice point, one thing to remember is that at least the intention of the law, now as an organization you may want to do more, but the intention of the law here is that if there is school available for the child, then the leave is not available to the parent. And if the kid has the capacity to go to school, and I'll use our school districts as an example. It's an opt-in, opt-out. So the school's open today, and kids are welcomed. So if that's the case, then as an employer, the leave isn't necessarily entitled. Now, if it's a hybrid model where the kids, and this is pretty common throughout the state, where it's 2 in, 3 at home, or 3 in and 2 at home. In those scenarios, in the hybrid model, you are allowed to grant the leave, and they're entitled to the leave, and it's somewhat like an intermittent FMLA. Employers and employees are encouraged to work out the schedules together, and it is something to really try and focus on, because the law is, in a lot of ways, when you read, and most of this comes through the FAQs that the Federal Department of Labor has issued over the course of the last 6 months, but they've really encouraged on the intermittent to have the parties coordinate schedules that work for both, and they haven't dictated how the law should play out in that area in as much detail as maybe some would like. That being the case, certainly our recommendations to clients is that if you have someone that is requesting intermittent leave, that you should grant it. But there are things to consider. First of all, the intermittent leave, and granting that intermittent leave, you have to take into consideration whether that person can remote work. And if they can remote work, do they necessarily need to be there with their child? If you have someone that's in preschool or early elementary, there's maybe different considerations, but I've got a middle school student in my house, and quite frankly, not only does she not need my help, she doesn't want it. I'm not walking into her room without being heavily armed, quite frankly. So those considerations in the age of the child plays into it. And then from a documenting standpoint, it's important that, and they call for it in the FAQs, is that there's documentation to designate that the school is gone into remote learning, and the days that the remote learning is required of the student and the child, pardon me, and also they also ask for kind of an attestation from the employee that confirms that they need to be home and that they are the child care provider for that student. So all of these things should be in there, and they're important because if you're granting the leave and you're going to take and we didn't want to get this to become too much of a tax program, but as many of you know, you're allowed to take a payroll credit against the cost of these benefits, and we'll get into the cost in a minute. If you're going to take that credit, there's a good chance you may be audited at some point. So you're going to need to be able to demonstrate that when you've granted the leave under 5 for school or place of care for a child, then as a dependent, you've got documentation within that employee's file that will support that you granted that leave and it was a legitimate leave. The last item 6 is really just a catch-all. It was put in the very beginning by the Department of Labor to allow them, if the virus took any type of other form, and it wasn't COVID specifically, because this was part of the initial law that was rolled out the very beginning of April, that they were able to transition and grant benefits if there were other, if there were other leave and other health considerations that are related to it. Quite frankly, I haven't had an issue under 6 come up yet, and we've been dealing with this on a daily basis. So I think we may be past the need for 6, but it was a safety net by the Department of Labor. Okay. So a couple technical points, and I've run through some of this already, so I'm not going to belabor too much, but just on the eligibility, I think it's important. All employees are entitled to the emergency paid sick leave. So as all of you probably remember, FMLA works under the concept that you've got to work 1,250 hours within the prior 12 months, and that you've got to work within an employer that has 50 employees within, I believe, a 75-mile radius, if I recall correctly. That's not the case here. So the emergency paid sick leave is essentially for everyone. The enhanced FMLA, which are really those bullets 3 through 6, you've got to work there for the 30 days. So that's essentially going to be everyone. And if it isn't everyone, it'll be everyone after a month. They'll roll into the benefits of this. So I know a few employers had thought that they needed to qualify under the FMLA requirements, and that's not the case. Now, the one thing I will say, we talked about exceptions before from an employee perspective, if they're a healthcare worker, there is an exception for employers as well. And that exception talks about employers that are small businesses. It's a 50 employees or less. Now, I've had a couple groups that have come to me on this. It's not you're just removed from the obligations of the FFCRA if you have 49 employees. You're removed from it if, because of your size, these benefits would create a hardship on your operation, and you have to be able to demonstrate that. The groups that I've worked with, the small employer groups that I've worked with, I've had a few that have taken it and taken that position, but several have ultimately decided not to, because you're forced into making that decision without there being a determination on it unless there's a claim. So if I'm a small employer and I decide that I'm going to exercise the hardship and not grant leave benefits under the FFCRA, so I deny it to the employee, there's no intermediary determination that you can go to the Department of Labor and they would sanction you taking that position. You're not going to learn about it unless there is a claim against you by the employee who was denied the benefits. And then you wait, and ultimately, whether it's an administrative proceeding because they file something with the Department of Labor as a claim or a complaint, pardon me, or if they go into, because they have the ability through plaintiff's counsel or as a pro se, they file in federal court. So, most groups don't want to roll the dice and they decide just to grant the benefits because you don't have the ability to make a clear determination. All right, leave considerations, we've already touched upon those, so I'm going to skip over that for now. So pay entitlements, and most of you are already pretty well aware of this, but we talked before about the 6 elements that qualify. The first 3 are really COVID related to the individual employee. And in each of those scenarios, they get 100% of their wages, up to $510 a day for that 80-hour window. And it's a little different than the state leave, which I'm going to flip over to a slide to talk about the quarantine leave law in a minute. But the 80 hours essentially is, the concept here, and you can see the aggregate total of the 5,100. The idea here is to give 2 weeks of paid leave to an employee for any of these circumstances. Now, they do not necessarily need to be concurrent. It doesn't have to run together. The idea here and the anticipation, obviously, is that the quarantine period is 2 weeks. So if someone tests positive, that they go out for the 2 weeks, and that window would be exhausted, the 80-hour window. But you can have, and there have obviously been, and they're almost daily or weekly now maybe, with the CDC and even New York State Department of Health, changes in our approach, whether it's to wear masks, whether it's the quarantine period, and whether you should or shouldn't be tested. So there's been a lot of indecision, unfortunately, that we've had to follow, and particularly employers have had to follow. So I have had a number of groups where, and the easiest example, someone goes to get tested, you keep them out for that window of time until the test comes. And now, what I'm seeing, at least for my groups, is that it's a day to go get tested, and then it's several days for the results to come back. Some groups are a little quicker than others, but you have an employee out for 3 or 4 days even before you know that they're negative and they can return to work. Well, that's now 4 days, or presumably 32 hours that they would be paid under the Emergency Paid Sick Leave Act. So they still would have the remaining 6 days or 48 hours if they subsequently did test positive, or they had to test again and took another window of time off work. The other leave provisions, which are a little more complicated, but I think most groups are managing through it, are where employees are caring for an individual under quarantine. And in those circumstances, or that catch-all of number 6, which is substantially similar conditions, they're going to be able or eligible for 2/3 pay up to $200 a day, and for a total of $2,000 total for that 80-hour window. And again, that's for caring for someone that they were that they're a primary care provider for. The final form of pay comes for the school. Now, the school's a little bit complicated in the sense that the money's actually coming from the two separate laws. So we have the emergency paid sick leave, and then you have the enhanced FMLA. And the concept here is that the employee would get the first 10 days from the emergency paid sick, but they're not getting it at the 510, they're getting it at the 200. So the individual will go out, they'll get the 200 a day, or 2/3 of their wage up to the 200, and they would get it for the first 10 days, and then they would continue for the following 10 weeks to get to the 12-week FMLA period at that same rate, but they're getting it under the enhanced FMLA. Now, why is that relevant? Because you could have someone who's taken time under the emergency paid sick prior to taking leave for their child for school purposes. And in that scenario, they would still get the 10 days, but an example would be that, and I'll use myself. Let's say that I had taken 2 weeks back in May for quarantine. During those 2 weeks, I'm out, I'm getting paid the $510 a day, and I return back. Now school comes around, and now I need to take leave for my child. Well, I've already used my 80 hours. I only get it once. And there I did it again to all of you. I only get it once. So I'm required now, although I'm entitled to 12 weeks under the enhanced FMLA, the first 10 days would have been paid under the emergency paid sick. That's not available to me. I do, and it's only at the employee's election, I can use my PTO, but I cannot and am not eligible for any pay under either of the benefits. Where the pay then kicks in under the enhanced FMLA is on the 3rd week, or the end of the first 2 weeks, which would have been the first 10 days would have been unpaid. Then I segue into the enhanced FMLA for this, which would be $200 a day for the $12,000 total. Now, I will say this, it's a bit confusing for some. Most groups that I work with typically are just paying the employees straight out for the 12 weeks at that cap, and they're dealing with it later. They are, I would say I'm certainly encouraging them to take the payroll credit. I've had a couple groups that have been a little confused by it. Municipal employers, there are some limitations on taking the payroll credit. So, be aware of that if any of you are connected to municipal employers. All right, so last item for me before I pass it off to Matt is, as I'm assuming most, if not all of you know, there is also a New York quarantine leave law, which is the equivalent of the emergency paid sick in many ways. It became effective on March 18th of this year. Unlike the emergency paid sick leave, the federal law, there's no termination date. And that's a very interesting distinction that I think a lot of employers are now just picking up on. And this may, because of where we're at, both in terms of just where our numbers are and the reality of vaccines or lack thereof, that we could see this law continuing forward for a pretty significant period of time into 2021. It applies to all employees, full-time, part-time, and the leave entitlement is really based upon the size of the employer. And I've got a chart a couple slides over which will walk us through this, but larger employers are going to have the responsibility to give the benefit for 14 days. And there's a little different counting process to the state law than the federal, which I'll also explain. Smaller employers the benefit is either just unpaid leave or it's paid sick time for 5 days. So it's segregated into 3 groups, and we'll walk through those elements. I think the important thing of this law has had a lot more, well, not a lot more, I think both have, but this law certainly has had an evolution since its enactment back in March. First of all, which I think is one of the more significant items, is that the law itself, when you read it, and it was like many things that have been put into place this year, it was slapped together with, I would argue, a little lack of foresight. And we've seen an evolution of how this law has been interpreted. First, and I think most important, is the law required that you're only eligible if you had an order of quarantine from a government entity. And you can see in my slide here, because we've been doing these programs for a while, that government entity piece, we've actually, it's now also inclusive of healthcare providers. So before, you really had to go to your local Department of Health and say that you needed quarantine or to be isolated because of a positive test, and that's no longer the case. And it could be exposure too, but now a healthcare provider, a doctor's note, can put the person out under the state law. I think also another piece to the law, which just goes to the lack of poor drafting, I guess, and I apologize for those of you that may have family member that worked on this bill, because I'm sure it wasn't easy to get it passed, but there's a lack of clarity in terms of how many times individuals can use it. And we're now seeing it where there's a question of people going out from multiple positives, or sometimes there's false positives, but you still have to put the employee out. Does the employee, and is the employee granted additional leave, or is it just a one-time only leave like the federal law? Here, the guidance that we've received now, and it's more directly from the Department of Labor, is that it is now entitled to up to 3 periods or windows of leave. Now, each one of them is for a 14-day period, but employees are allowed to exercise the leave under the quarantine leave law. There has been no direct guidance on whether all 3 are supposed to be paid. We have been told by a representative in the State Department of Labor, unfortunately the representative retired 2 weeks ago, that there was going to be a memo from the DOL, state DOL's legal counsel, that would identify that only the first window is to be paid. We have not received that memo, and now this gentleman has been retired for about 6 weeks, and we still don't have that memo. So I can tell you, we're advising clients right now that it is first one is paid, second and third are unpaid, but we're holding our breath candidly, because there is nothing directly, we were told in an off-the-record conversation regarding this, so nothing was told. We have nothing in writing, let me put it that way, regarding this. So let's just get to, and let me walk through who's got to provide what. So employers of 100 and more employees, you've got the responsibility for the 14 days. Now, let's just talk about the calculation for a minute. The 14 days, the way they're calculated is actually how many, you don't get 14 paid sick. This was another point of confusion in the beginning. It's how many days you would have regularly worked within 14 calendar days. Most folks, that would be 10 days. If you're a full-time employee, that would be 2 weeks of pay or 10 work days. But because of alternate schedules and part-time and all of that, that could mean something different depending on this specific employee. The second group of employers are those employers with 11 to 99 employees, which is really a big bulk of employers that are, small employers to not quite mid-size or almost mid-size, I would say. I kind of view mid-size as 100 to 500, but that group are required to provide 5 paid sick days. And, the concept is after the sick days that individuals will be eligible for PFL or disability leave to continue their window of quarantine. But the first 5 would be employer responsible for payment. It also includes, for those that have to provide 5 paid sick days, Employers that have 10 or fewer, but have had a net income of $1 million or more on their 2019 taxes. So that's something else to consider. If there's a small number of employees, but it's a larger enterprise, they'll also be obligated to the 5 days. And then the final group are those with 10 or fewer that are under the $1 million threshold, and they have to provide unpaid sick time during the quarantine period. So that's how this breaks out. I would say, one thing that's important to remember with this, and just to kind of continue on this slide, is that these benefits are provided to employees and should run concurrently with the federal law. And that's significant because remember, the federal law allows for the payroll tax credit to help offset and pay for the cost of this leave. So you're entitled here under the quarantine leave law to run it concurrent, and essentially those 80 days should fit within the 14 calendar day window, and the benefit should then be paid for through the payroll credit, and that's completely permissible. I think some groups, remember there's a quota or a cap at that $510 a day. So if you have a high wage earner, you could end up having to, because under the state law, it's full salary. It's their base wage. So if they go beyond that $510 on their daily rate, then the employer would have to make that up, and it would not be, you would not be eligible for the federal payroll tax credit on that. But nonetheless, you would be able to offset a significant portion of salary. Okay. And this is for all employers with New York operations, just so everyone's aware. So what benefits are not available? A couple of things I think are really important here. And number one is that employees that are asymptomatic and have been told to stay home but are able to work remotely, those individuals, if you're working remotely, you're not eligible for this benefit. You're working. The other thing that we'll get into a little bit here, I think I have it on another slide, but just to touch upon it now, is that this law has, the state law, quarantine leave law, has identified, at least initially, it was those that engaged in international travel to areas that the State Department deemed inappropriate and were on this restricted list, that if they took it for and they were traveling for non-work purposes, they weren't directed by their employer or company, that they have then invalidated themselves for benefits under the quarantine leave law. This now includes individuals that are taking vacation in states that are on the restricted list. And this has become a much more problematic and administratively difficult matter to manage, because over the summer, and I think the vacation season this year has been a little bit odd, to say the least, but employees still have taken time, whether to see relatives or whatnot, and some have taken it even to go to states that are restricted. If they go there, they do have to quarantine, but they also have now invalidated themselves for benefits under the QLL. So I think that's important to remember. Okay, I think we've touched upon the fact that the Families First Federal Act runs concurrent, and we've talked about the exemptions and the travel considerations. So I really think at this time, before I pass it off to Matt, if we can just open it up for any questions regarding either the QLL or the federal Families First Act.
Hi, Mike. This is Deb Carr from ARC of Rockland.
Hi.
My question is around the COVID-19 sick leave, the New York State leave. I do have the guidance from the Department of Health and Department of Labor that talks about that second and third leave period for healthcare employers. I'm trying to determine, if we are included in that, because it does define healthcare employer, and one of the definitions is a residential facility. So if my employees don't work in the residential facility, do they qualify? That's part A. And then B is it does say up to 3, in no circumstances more than 3 leaves. I was not under the impression, but I like your interpretation that second and third leaves are not paid. I just wanted to clarify that that's what you're recommending. So I just
that's what we've been certainly recommending. I do think that ARCs have been, I'm interpreting them as healthcare providers. So, and unfortunately, unlike the feds who have now defined direct contact and what really is a healthcare provider for exemption purposes, the state has not. So there's a lot of what ifs with the state law in this area. And quite frankly, we've been advising clients that you can take the position of paying only for one of the 3 leaves for the healthcare employees, pardon me. But we need to be mindful because all we have that on, sadly, is an off-the-record conversation with an administrative rep from the Department of Labor that is no longer there. So it's fair to say that it's an open issue. And I've had some groups that have said, look, we're just going to grant it and we're going to pay for it. And I've had others that have been more aggressive. I think there's an argument either way, which is it's not a great way to practice law, and it's not a great way to run your business. But the Department of Labor hasn't provided any information that would provide any greater clarity to this at this point.
I have, I'm sure you have this, but if I email you this guidance that I'm looking at, maybe I can, I don't know if that's helpful, but my question is related to that, but I'll send it to you. I'm sure you have it, but just so you have it, because it is something.
Yeah, no, I'm familiar with it, but if you want to send it to me and with your question, and we can try to hash through it a little bit further for you, I'd be happy to.
Thank you, I appreciate it.
Sure. Okay, so why don't...
I have a question.
Sure.
I know that we talked a lot about when there's a leave necessary. What happens if it's an employee because they're immunocompromised and they choose not to come into work? What recourse does the employer have, or is the employer required to grant them, either leave because they cannot work from home, or the ability to continue to work remotely?
Well, so this question or this issue's come up quite frequently, and it really needs to start with, well, what's and who is directing the employee not to come to work? If the employee is taking the position on their own that
Yes.
they're not coming into work because of their condition, that's insufficient. And I would argue that it's insufficient under either law, that you do need documentation to support it. Clearly under the QLL, you need it. I don't think there's any question with respect to that. And I would say under the federal, you would still need that documentation to support the leave. So, because I've had a number of clients have that circumstance, and particularly in the beginning, when the employee, well, most individuals were frightened even to go to their own doctor. They don't want to leave. They don't want to leave their home. And in that circumstance, different groups have been a little more lenient, but I think the law is pretty clear. There is some argument the employee is experiencing symptoms. It doesn't say that they're required to have a note to support the symptoms, but they still have to seek medical treatment or a diagnostic analysis, which really means testing. So under either law, I would argue that without a doctor's note, they're not qualified.
Okay, so that the doctor's note would be sufficient.
Yeah, I clearly now, early on, I would say no under the state, yes under the feds, but now I think it's pretty clear that under both laws, a doctor's note is going to be sufficient.
Okay, thank you.
Okay, so why don't we, just for sake of time, and if you have other questions, we'll certainly happy to answer them, whether it's today or through email. But let's pass it off to Matt, and we'll get into the next section of this regarding leave. Matt, are you there?
see. Did that pull up the right slide? For some reason, I can't see which one's up.
Okay, I've got you on your opening slide here.
Okay. So, like Mike talked about with the entitlements and benefits under both the federal and state law, the important thing here is to be organized, especially at a time like this where employers are receiving lots of requests, whether it be under the FFCRA, the New York quarantine leave law, or even the FMLA and the ADA. So something that may be helpful for you is to go through each of these policies, see what's required under each one, and reevaluate your internal processes, especially for things that have been in existence already, a traditional FMLA leave or ADA leave. Maybe make a chart, a grid, a spreadsheet, whatever might work best for you, and mark down the steps so that for each employee that takes or wants to take leave or apply for an ADA accommodation under this, you're checking off all the boxes. You're making sure that you are requesting the right documentation, requesting at the right time, requesting it from the right individuals. So under the FFCRA, there's a very limited documentation requirement. There technically doesn't even have to be any documentation because the request can be made orally or in writing. For 1 through 4 and 6, everything outside of requesting time off for taking care of a child whose school is closed or care provider's closed, the employee just needs to provide their name, the dates they want leave, the reason for the leave, whether it be one of those 1 through 6, and a statement why they're unable to work for that reason. Beyond that, they don't have to provide anything else. If they're saying they're going to get tested, the employer, you can ask what date are you going to get tested. You can ask for the result, but you can't necessarily demand proof that they got tested or sought a medical diagnosis. Then when it comes to the taking leave under number 5, whether it be under the paid sick leave or the expanded FMLA, just need to provide their child's name, the place of care, the school, or the individual provider that's unavailable, and a statement that no other suitable person is available to take care of the child. Now, suitable is a subjective term. We don't believe that just because there is a child care service available that you haven't traditionally used or aren't comfortable with using, that disqualifies you. Suitable is subjective to each person. Something that can be very helpful with the FFCRA, although it's not required, is to have a pre-made form for employees to fill out. This can include the numbers, all the information on there, why they're taking leave, when they're taking leave. You can also use this as an opportunity to ask whether, if it's within your policies, to supplement their leave with their own paid time off. Obviously, this might change throughout. We urge employers to be amenable and flexible if this does change, but just so that you can know going into it what the situation is. Importantly, with the FFCRA, there was a recent court opinion that said these can't be, or the requirements can't be a condition precedent or precedent to taking the leave. You can't require that all these documents be in before the person is eligible to take leave under the FFCRA, which is different from the state law, which you need the order of quarantine, whether it be from the local health department, which, as Mike discussed, is most likely not the case, or a letter from your doctor saying that you need to isolate or quarantine. And now, why it's important to have this all documented is, one, for your internal tracking to know if the person's met their 80 hours or whatever they're eligible for as a part-time employee, to keep track that you did pay them the first time under the state law, and now that's their second or third time taking leave and they're not eligible for pay. And under the federal law, for tax purposes, you want to make sure you have all the proper documentation in case that audit does come, that you can properly provide documentation and say that this was all above board and handled properly in the moment. And this might be something where you want to reconsider visiting your travel policy. If you're restricting non-essential leave at this time, or travel, whether it be personal, obviously you can't tell someone not to travel, but you can ask that if they are traveling to out of state, that they let you know what state they're traveling to. So this way, if they travel to Virginia or South Carolina or any other state that is on the New York travel list, when they come back and they apply for that state leave, they might not be eligible for pay under the law. So these are important things to have documented and be aware of ahead of time. When it comes to the ADA or the FMLA, yes, there's the expanded paid leave under the federal law, but coronavirus or COVID might be a serious health condition in its own right and eligible for traditional FMLA leave. So if someone's applying for that, you want to make sure you go through the traditional steps, have things in place so that you can receive the medical certification, what their time frame is, approve that leave, and have that ongoing dialogue with them. And because of the health issues that COVID might pose to someone with a weakened immune system or is suffering from a disability, this might entitle them to some accommodation under the ADA. So when going through ADA leave, you want to make sure that you're an eligible employer. If you have 15 or more employees, you're covered under the ADA. You want to review your processes and forms. People might say, I have diabetes or I have high blood pressure, other things that makes it, they're at higher risk for being around COVID, or people who may have it. So they might request things such as working from home. If people are coming back to the office, that could be a reasonable accommodation. Could be adjusting their work schedule. So maybe they come in earlier in the morning or later in the day when there are fewer people in the office, so they can not be as close proximity to others. But you're going to want to make sure that you're asking for the proper documentation. If you're getting a doctor's note explaining why this person needs to come in earlier in the morning, why this person most likely might need to work from home, and having that ongoing dialogue with them and having it all documented just so you can prove that you went through the interactive process, had that open, transparent discussion with the employer, with their healthcare provider, if you have HIPAA clearance, and just making sure that you're covered on the employer's perspective. You want to go through it slowly, carefully. You don't want to have it says on here, a knee-jerk reaction and deny leave or deny an accommodation just because it's a stressful time, you need someone to be in the office. You want to make sure you're still going through the proper steps, slowly, carefully, and working in conjunction with the employee. Now, some issues that might arise under these leave requests, some of them were touched on by Mike earlier or in your questions. But first and foremost, is there a legal entitlement to leave? And that's why having documentation is so important, especially tracking what leave's already been taken, whether it be under the FFCRA or the New York quarantine leave, whether that person just traveled to a restricted state on the New York quarantine list. You want to be able to make sure you have all the things in your toolbox to ensure that you can make the proper determination and decide whether there's legal entitlement. If it's under the ADA, if the accommodation might be too harsh a restriction or an undue hardship on the company, then you want to be able to show why that's the case as well. Is the employee paid if leave's provided? Again, that goes to what's already been taken, what type of leave is, and the scenario behind it. But you want to also review your internal policies and see when they're allowed to take paid time off, if they're on unpaid leave, and things like that. And then Mike just talked about with Lena's question, what if an employee is too scared to come to work? Now, Mike covered this under the federal and state coronavirus laws, but this might be a situation where someone does have a disability or illness and they're covered under the ADA, and they might need more of a reasonable accommodation to either work from home. So they're not seeking paid leave, but they're looking to either work from home or work an adjusted schedule. And that's something where you go through the interactive process and have that conversation with them. If this is purely because they're nervous to come to work or don't want to be around COVID or have the chance of catching it, that's an entirely separate issue, and they wouldn't be necessarily covered under the ADA, FMLA, or state or federal leave laws.
Right. Matt, if I could just jump in for a second, because I've had a few of these situations now where, and they've kind of worked both ways in terms of our advice. We've had individuals that said, listen, I just don't feel comfortable. And that's a very big distinction from somebody that has a clinical disorder related to it. And I've had the other side, which is doctor's notes that have identified clinical anxiety disorders related to coming to work. And it's created or brought out other reactions in the individual that have required forms of treatment. So you do have to assess each, as you always do, you assess each situation as they come up and based on those facts. But you could, although someone may not qualify for these two types of state or federal leaves, you still have to process possibly under the ADA. So I'd just be aware of that.
Sure. And on a similar note, with the person's nervous for themselves, but in New York, we have what's called Matilda's Law, although it's not actually a law. If someone is living with or caring for an elderly individual or someone with a compromised immune system, Governor Cuomo passed this more as a policy initiative. It's not actually a law on the books. So if someone is concerned with coming to work because they take care of some an individual that falls under this category or might be deemed that qualifies for Matilda's Law, it's something, again, that you're going to have to look to on a case-by-case basis. Maybe there is some kind of further anxiety or something that might be treatable or fall under the ADA. But in most circumstances, it's not an actual law that needs to be followed, but more a policy consideration. If someone claims to have COVID symptoms but has no diagnosis, so under the state law, you need to have that order of quarantine, that order of isolation to be eligible for benefits. Under the federal law, like Mike said, this is good faith effort on both parties' parts. Hopefully we don't have people trying to take advantage of the paid leave and save it. Hopefully they don't ultimately need it, but save it in case they do. But yes, someone could say that they're suffering COVID symptoms and they can say that they're going to get treated, but the DOL in their FAQs has issued guidance saying that you can't require that the employee give you proof of seeking medical treatment or diagnosis. The only thing that can be asked is whether they're going, and the employee might tell you, yes, I'm going to get my seen by my doctor on Wednesday, but you can't ask for proof that they actually visited their doctor or whether the doctor said yes or no, you do have COVID-19. If people do not have childcare, like I said before, the term under the FFCRA is suitable. So this can be subjective. You might hear of a childcare service or a nursery school or something that is accepting, is open, and it has room for employees or for people to drop off their children, especially if they're a first responder or an essential worker. But suitable doesn't mean every childcare service that's available. So if that person does not feel comfortable with the options that are made available to them and their traditional daily childcare provider is closed, then this is still something that they most likely will qualify for. We kind of covered what documentation you should be looking for, but the last consideration is, what do you want to do as an HR department, as business owner, from an optics and public relations standpoint? Are we going to be more lenient with granting leave at a time like this? Are we going to be more lenient if it's possible to allow employees to work from home? But most importantly, as always, with any kind of leave or accommodation, we want to make sure that we're applying it equally and consistently. If we're bringing people back into the office and we want to make sure that it's not picking and choosing, or you try to make the person who has 5 kids and they're all home from school come into the office and tell them that they're going to be terminated if they can't come in. These are obviously, that's very clear there, but want to make sure that you're potentially conducting a diversity analysis when you're doing things like this, but you just want to, again, just if you grant leave for one person under a very similar set of circumstances, you want to make sure that you're granting leave for another person. Or if you're not going to grant leave, be able to provide legitimate business reasons and underlying reasons why you're not granting it. So again, just equally consistent across the board. That's what I have for this section. We can open it up to questions before we move on to some other leave considerations.
Okay, why don't we, just being cognizant of the time, I'll jump into the next section here. Let's see here. Matt, I may ask you just to help me along a little bit here.
Sure.
Okay, so two concepts I want to touch upon quickly that are related and sometimes are a bit afterthoughts that we want to put a little bit further ahead in people's minds in dealing with these leave considerations, particularly related to the federal and the state quarantine laws. The first is health insurance. So, health insurance in the FMLA, in its very simplest sense, if you grant someone FMLA, you're providing them health insurance on your same plan and under the same pay arrangements that you would have if they had continued to work. And that holds true here, and it's easy enough. I think where we're finding things getting a little more difficult is that, organizations are going through a lot of changes. And we'll talk a little bit about later on in the unemployment, the shared work program and reduction in hours of employees or furloughs, which could trigger a COBRA event, right? And COBRA, again, is the continuation of health benefits post-employment, but it doesn't necessarily mean that it's just separation. Furlough can trigger COBRA, so can a reduction in hours potentially trigger COBRA. So you need to work with your healthcare broker or directly with your provider to make sure that you recognize where their COBRA event may have occurred or with counsel. And if you have obligations to notify, to advise the employee as such. I think what I want to highlight on this particular topic is really the pay arrangements for those that are going out of work. And whether it's COBRA or even if it's not COBRA, if it happen to have an employee that's going out, and I have one organization, a larger group, that decided to conduct furloughs back in April. And they decided as part of the furlough to grant continued health insurance coverage. They weren't going to COBRA the folks. They didn't even know how long the furlough was going to last. So they felt like what they would do, and employees within this organization had a co-share on the premium costs. And the employer here said, look, we're going to pick up the health insurance for you, and we'll pay for the full health insurance while you're out, but we're going to furlough you because we just don't have the work right now. So they furloughed, and they went month by month. But within the furlough, they included a provision that required employees, when they came back, that they would make whole on their health insurance. So there was an agreement, a repayment agreement. And that's important because it's not easy, and those of you that have gone through it, where an employee owes you money, whether current or former, it almost doesn't matter. Oftentimes, you're left in small claims court chasing after that money, and if you don't have an agreement, a repayment agreement, it becomes very difficult to work through that. Employers do have the option that if there is a copay requirement, I'm using copay, but it's specific for the premium contributions from an employee, that they can be asked to pay for that, much like they were when they were an active employee, to write the organization or the employer a check for each month or whatever the cycle may be to contribute to their health insurance as if they stayed employed. Many groups elect against that, understanding the hardship that it may cause employees. But I have had some groups throughout this last 6-7 months where they have asked their employees that have gone out on furlough or extended leave for them to make those payments, understanding that unemployment benefits with the, it's now expired, but with the $600 add-on has left many individuals out on unemployment benefits, receiving as much or sometimes even more than they would have earned if they continued to work. So when they didn't feel like it was a hardship, they continued to ask for those payments. Okay, Matt, if you can flip us to the next one. The other thing that I want to touch upon here, just in terms of leave considerations that aren't directly related to the law, but we should be mindful of, is how are your other policies working, right? We talked a little bit that you can't require the use of PTO in conjunction with some of these laws. It's at the employee's discretion, and that's pretty easy to understand. I think the more difficult part, and there's two items I really want to touch upon here. One is, furlough versus layoffs, and we may be getting to this conversation a little late. This is a conversation that was very active in the spring and early summer. Groups that have had to do what they needed to do or sort of gone past it at this point, but and made those decisions. But I will say this, that there is a distinction between furlough and layoff. Layoff has more of a legal concept, whereas furlough is more a term of art, but they are different. Furlough is the conception that the employee is coming back to work at some point in time and that you're trying to maintain the relationship. Whereas a layoff, that person's let go and there's really no indication or commitment by the employer that that individual will come back. Furlough doesn't guarantee the return of employment, but the idea is when you furlough an employee is that you want to maintain the relationship, and most organizations will continue some form of benefit, whether they're allowed to use PTO while they're out, whether they're allowed to continue health insurance without COBRA, things of that nature. So there is a distinction. The other important thing is that furlough and layoff, and I'll touch upon this maybe a little bit under WARN, but WARN is the notification that you have to provide of a mass layoff, and there's federal and state WARN laws in New York that you need to be aware of. They work under different parameters, but the idea is it's advance notice to employees of job loss. If you're furloughing an employee, you don't have to give them that because they're returning to work, but you should be mindful that there is case law out there that if a furlough extends beyond 6 months, that's tantamount to a layoff, and that you should have provided WARN notice to those employees. So when you make that, and if any of your organizations are still dealing with layoffs and furloughs, those are certain considerations you should be mindful of. The other thing that I would add, just because I've seen a bit of an uptick in this, is severance pay. So those organizations that are or have been in a position in the past to include a severance pay program, whether it's a policy within your handbook or whether it's even just a practice where you've provided severance to employees going out, I think you need to be mindful. I've got a gaggle of plaintiffs' attorneys now throughout at least the Hudson Valley and certainly within the city that are examining employer practices pre-pandemic and whether they provided severance and if there's an obligation to continue it going forward. There's kind of a line of disconnected ERISA cases. ERISA is a federal law that deals with retirement plans. And these line of cases, if you want to call it that, because I'm in the middle of arguing a couple of these right now with plaintiffs' counsel. They haven't filed a complaint yet, but we've got demand letters. And they're arguing that the severance plan, one was within an employee handbook. The other one I'm thinking of wasn't even that. It was just a practice of a company that granting severance in the past is an obligation to continue it. So organizations need to examine what their practices are. And if they're not comfortable committing to those practices or those policies, to make sure that there is a clear and pronounced removal of that commitment, of the severance plan commitment. I know a lot of organizations and I'm sure our firm is no different, could never imagine that we're in the situation we are right now as an employer. And to that point, some organizations, whether it's just based upon their financial ability, their benevolence towards their employees, but they have these policies that exist or practices that grant separation and severance pay in certain circumstances. And you wouldn't imagine getting caught in a circumstance such as this, and the policy doesn't envision that, and now you're committed to it. So just something to be aware of, and to just to know that there is a group of plaintiffs attorneys that are very, very focused on this right now within the metro area. All right, Matt, why don't we flip it back to you for New York paid sick?
Sure. Okay. So the New York paid sick leave law was just passed in April and goes into effect on September 30th of this year. So that's next week. But employers don't have to allow employees to use their sick time until January 1st, 2021. So the way that sick leave is accrued under the law, it can be done on one of two ways. It must, if you do it on an accrual basis, employees must accrue at least 1 hour for every 30 hours worked. That would give a full-time employee working between 2,000 and 2,080 hours, a potential accrual between 65 and 60 hours. Or employers can give the full benefit on January 1st or whatever the calendar year the employer chooses, the first day of that calendar year. So in terms of entitled use, employees or employers with fewer than 100 employees must offer at least 40 hours of paid sick leave time each calendar year. Now, the only exception to this is if the employer has fewer than 5 employees and turned a net profit of fewer than $1 million the prior tax year. In those situations, you still must offer 40 hours of sick leave, but it does not have to be paid. So again, if you're fewer than 100 employees, generally going to give 40 hours of paid leave. If you have 4 or fewer employees and made less than $1 million in net profit the year before, does not have to be paid. If you have more than 100 employees, employers must offer at least 56 hours of paid sick leave time. So the reason I mentioned before that you might, under accrual basis, someone might accrue up to 65 or 70 hours, even though they don't have the ability to use all of those hours. Unused time does get carried over to the next year. Although there is no requirement under the law to pay for unused sick time or to pay unused sick time at separation of employment. But just know that it can accrue. So even though someone uses their full 56 hours, they still might have another 10 banked starting in January. So it's important if you're going to choose the accrual basis, because since accruals will start next week, even though they don't have to or don't have the option to use it until January 1st, if that's what you choose, you still must have processes in place to account for that accrual starting next week, so that come January 1st, that individual that worked October through December has some sick time available to use on January 1st. In terms of using the leave, the law is very broad in the description that it uses. You can use it for any mental or physical injury or health condition of the employer or employee's family member. That's regardless of whether it's diagnosed or requires medical care. They can also use it for the diagnosis, care, or treatment of that mental or physical illness, injury, or health condition, or an absence from work when the employee or employee's family member is a victim of domestic abuse, family offense, sexual offense, stalking, or human trafficking. In addition, likewise, the family members included under the act are very broad. Child, biological, adopted, step, foster, legal ward, anyone that you have local parentis of, spouse, domestic partner, parent, sibling, grandchild, grandparent, or even the parent of an employee's spouse. in terms of actually utilizing the time, employers can set a reasonable minimum increment, meaning the minimum that an employee must take if they choose to use any sick time, but it cannot be more than 4 hours. So you can say that you have to use at least 1 hour, at least 2 hours, but you can't say you have to use 1 full day's worth of sick time every time you want to take sick leave. This just talks more about the definition of family member. Carrying over sick time, which we already discussed. So again, this is something where you're going to want to take time to review your current handbook policies and see what your current sick leave entitlement is, if there is any. If you're already providing more or an equal amount of sick time as required under the law, then you don't have to change anything. If you just say, if you have 50 employees and every year you say you're entitled to 40 hours of sick time, you're set. If you have 150 employees and you only allow them to take 40 hours of sick time, this is a situation we're going to have to increase that to 56, at least 56, starting on January 1st. If they do accrue based on hours worked, you want to make sure that it's at least 1 hour for every 30 hours worked. Starting September 30th, if you have unionized employees, if you're entering into a CBA, you still must offer in the CBA sick time equivalent to or in excess of what's required under the law. Under CBA, this can be given under a couple different ways, not necessarily just straight sick time. It could be leave time, compensation, or other benefits, but in the CBA, you must acknowledge the New York paid sick leave law and the requirements under it. From an employer standpoint, in terms of record retention and any notice you must give, if an employer asks or an employee asks how much sick time they've used or have available, you must get back to them within 3 days to let them know how much time they still have or how much they've used for the year. And you also must maintain these records for at least 6 years. And then separately, just with anything else in labor and employment, there's no retaliation against employees for requesting leave time or using sick leave time under the Act. And lastly, there are supposed to be regulations forthcoming. The commissioner has been granted the ability to pass those, but there have not been any passed as of today, even though the law takes effect next week. So when those do get passed, you want to make sure that following any additional guidance provided under those. Mike will talk a little about unemployment.
Okay, so Lena, I think we're mindful. We've hit
Yes.
11 o'clock now. So
It is
how would
11
you?
o'clock. We can, Doreen, I don't know if you can hear me.
I'm
If we
here.
can stay on a little bit longer, that's okay. People can leave. If anybody wants to stay and listen, if it's okay with Mike and Matt and with you for the timing, we can just continue. So for those of you who have to log off, thank you very much for joining us today. I'm sorry I wasn't here at the very, very beginning to welcome you all. I was having some trouble with my internet, but with that, thank you, and we will see you in November. I will be sending out a save the date for our November meeting, and that will also be a Zoom meeting. And those who would like to stay on, please do until Mike and Matt are completed with their presentation. Thank you.
Okay, so I think a couple points, and Lena, if it's okay with you, I've already given Lena the PowerPoint, so those that have to jump off, I'm more than okay with Lena sharing this document with you. And as we've done in the past, we're happy to answer questions as follow-up to this afterwards if you want to email us. So that's no issue. Those that stick around, there are only 2 more topics we want to touch upon, and I'll go through one of the 2 relatively quickly, and then Matt will touch on the last one. With respect to unemployment, I know there's a lot of questions and there's a lot of frustration. Employers feel that they're under siege. A, employees not taking leave. B, trying to get employees back to work. And then, C, if you want to add into that, is the cost of all of this between the federal and the state leave laws. And now unemployment is another dynamic to this, where unemployment benefits have changed somewhat dramatically. Now, if you had asked me a year ago, before we had been dealing with wearing masks and washing our hands for 20 seconds at a time, which I'd like to think we had these good practices before, but candidly did not. Unemployment was a very difficult thing for an employer to fight, in my opinion, to begin with, and it continues to be that way. But the distinction now, I think, is pretty significant in a few areas. One, the executive order, which was issued in mid-March by Governor Cuomo, removed the waiting period to allow people access to funds right away. As many of you may recall, the end of March, President Trump signed into law the CARES Act, which provided actually a number of different unemployment benefits. The most common or recognized is the Pandemic Unemployment Assistance Act, which is the PUA that many of you probably know it as, which also is the $600 a week in addition to your regular unemployment benefits that employees are able to receive. And they were receiving that for items, and eligibility there really went in a direction that was very different than how we knew unemployment. We knew unemployment as there's work available and the employee there's no work available for the employee and they haven't disqualified themselves. And in its very basic form, that's what unemployment has been forever. But here, where an employee now, because of COVID-related reasons, is not able to work, and that could be because of the employee themselves contracting or becoming ill through COVID, family member where the employee is a primary caregiver, school closed that's now removed the employee from their ability to work, job offer that's been rescinded because of COVID, or where the employees actually quit because of COVID, but they've had a doctor's note where, and this goes back to a comment that Matt made earlier, where they're compromised or even a family member's compromised and they feel like it's not appropriate to go back in the workplace. They've gone ahead and they've granted benefits in that capacity. So under the PUA, unemployment benefits have been, the eligibility component of it has changed dramatically. The other thing that's changed is the emergency unemployment comp has been added, which extends unemployment benefits for an additional 13 weeks. Traditionally, it was 26 weeks. Now it's moved to 39. Now, some of these pay enhancements have expired. Not surprisingly, the government's running out of money, and an issue that we'll deal with separately for many, many years. But these benefits have been running their course over the summer and spring of this year. The other thing, and Matt, if you can flip it, and this is something that's actually been around for a long time, and I know a lot of organizations this year have taken advantage of it, is in New York State, there is a shared work program, and probably been around for at least a couple decades, if not longer. But what it does, employers can apply to State Department of Labor, and they have to have a group of employees. It can't be just a single person, but if they have a group of employees where they're looking to reduce, and the reduction both has to be in hours and in pay, and it has to be between 20% to 60% reduction. So you really are taking somebody to a 4/5 or a 2/5 position that was full-time previously. And you can then, they can then file for unemployment benefits that would help in essentially provide partial unemployment benefits, which otherwise would not be available, right? Because the individual still has work coming to them. But here, and again, not a new program, but a program that's really become very popular and I've seen a number of clients utilize. So the shared work program, and it continues to exist even going into the fall now. The last topic, which is not a UI topic, but I do want to just touch on it quickly, it'll be the last thing on my end, is just the WARN consideration. So we've talked a little bit about furloughs and layoffs, and as many of you know, there's both a federal and a state WARN. And WARN works in a couple of different capacities. If there's a complete shutdown, where WARN notices will be provided. More often than not, that's not the way these work. They often work where there's a significant component of the workforce that's laid off, but not everyone. Standards under federal and state law are a little different. As you may know, federal threshold is 50 affected employees, and you have to provide a 60-day or 2-month advance notice of anticipation of that.
I think he may have froze. Well,
Generally, the state law is the standard. Sorry.
I think you froze there for a little bit.
Okay. Am I back now, Matt?
Yes.
Okay, good. So just to go back, the state law, because of the lower thresholds, is often how, for New York employers, we tend to start our WARN analysis. I think the big issue here, what I'm finding, is that employers sometimes are not mindful of this. And COVID created a very unique situation where you didn't realize you needed a layoff until you needed the layoff. It wasn't something that could be pre-planned. And there are exceptions, not many, but there are a couple of exceptions under WARN, and one in particular, which is the unforeseen business circumstance exception, which allows employers, because of a dramatic financial change in your work condition, that you do not have to give the advance notice. Again, that's being 60 days under the federal law. State law is actually 90 days. It's even more notice. But you can waive that notice requirement if there's an unforeseen business circumstance. Now, the waiver is not a complete waiver. It doesn't mean you don't have to give it, but you only have to give it from the point in time that you recognize you need to give it. So that may reduce the 90-day notice period to 45 or 30 days, where an employer recognizes that we don't have the financial capacity to continue to operate with our full complement of staff, and we have to conduct these layoffs. And we need to do it within X time frame, because this is when the money is going to no longer be available financially to continue salary or wages. So you're able to reduce the notice period under that. The exception, right, there's not a lot of WARN litigation, so it's not as if we have been able to rely on other examples of pandemics, thankfully, or even other circumstances. There's been a few hurricane and natural disaster cases that have allowed for this type of exception. There is actually a natural disaster exception that allows for a waiver of WARN notices. So the law hasn't really seen a lot of litigation under the unforeseen business circumstance, but there is an argument that COVID would apply there. That being the case, I think employers should be mindful that WARN is not forgiven because of these situations, and that notice is still needed and should be provided. And I talked a little bit about the distinction earlier between furloughs and layoffs. So be mindful, if you're in furlough status opposed to a layoff, you still may have WARN obligations. And if you're going to rely on this unforeseen business circumstance exception, you still are going to need to give some form of notice. It just may not be the full notice period. So Matt, I'll send it back to you for the last section here.
So in terms of expense reimbursement, we're thinking more employees are working at home. The job doesn't necessarily look like what it always looked like. So what are employers obligated to pay, if anything, for expenses? So under the federal law, the Fair Labor Standards Act, there's not a lot of protection. Essentially, the employer only has to reimburse employees should their expenses bring their net regular hourly wage below the federal minimum, which in New York, with the higher minimum wage, this is unlikely to happen, but it may. The expense, again, it would have to be for one required by the employer for the specific job or workplace. Obviously, working from home, if you require the internet or a cell phone or anything to communicate, if you don't already have one of those, that will very likely and almost definitely be fit under that definition. But again, it only has to be reimbursed under federal law if it brings an employee's wage below federal minimum. In New York, though, is much more stringent, not as stringent as some other states, but employers do have to reimburse employees for expenses incurred on behalf or for the benefit of the employer. So under normal circumstances, this might be mileage or fuel once the employee gets to work, if they have to travel to a client or something else. I know that's not necessarily happening right now. So other things to consider are postage costs. Maybe the employee has to mail something into the office for either internal office staff to take care of, or mail something to a client or customer. If they pay $15 to ship that package or ship that letter, then the employer is going to be responsible for reimbursing them. If someone needs to buy a cell phone or a landline or whatever it may be, maybe they live somewhere where they don't have great cell service, it's not reliable, but you need them to be on the phone and they needed to install a phone that they didn't already have, then that might be something that the employer has to incur some or all of the cost for. Where New York differs from more restrictive states like California is that employers don't have to pay for services that the employee already has. So if they already have internet in their house, the employer doesn't necessarily have to pay for it. But possibly if the employer or the employee needs greater bandwidth, depending on their job description, then maybe they have to get increased internet speeds, and the employer might be responsible for paying a small portion or a reasonable portion of that internet access. The same might apply for phone bills. I know a lot of people have unlimited data plans or talk plans now, standard for some, but if the employee is incurring additional data or talk costs, then the employer is going to be responsible for the minutes or data attributable to the employee's work. So these are important things to keep in mind, especially if people are going to be working at home for a prolonged period of time or have already been working for a long period of time. This may be something that employees ask for, but it's something that employers should be on top of and proactive in providing to avoid those issues. Yeah. Then, in keeping with the work from home, we don't have a slide on this, but something that may also be important to keep in mind is workers' compensation insurance. You're going to want to maintain your policy. There's a very real argument that someone could make that if they're injured in the duty of their job responsibilities while working from home, if they're getting up to go get a copy or send a fax or print something and they trip, will the employer be responsible? This is not something that comes up often, but there's certainly an argument that could happen. Maybe the desk chair that they're sitting on is not great for their back. Now they've thrown out their back and can't sit at the computer for a couple weeks. While maybe not common, there are certainly things that may come up and an employer may claim. So it's very important, as always, to maintain that those workers' compensation benefits, even while employees are working from home. And that's all I have on my end.
Okay, thanks, Matt. Lena, do we want to, I'm happy to, I've still got a little bit of time on my end. I'm not sure if Matt does, but I'm happy to try to answer some questions or send them
If
off.
there are people, we have some participants still here. If they have any questions and you're okay to answer them, why not?
Sure.
I have one.
Hi,
I have one. When we were talking earlier in the call about making the chart, with all the different possibilities, do you guys have a chart?
I don't have a chart personally.
The reason I'm asking is instead of everybody going through, if you had a client who had it or something like that, not that we would say, this is what you gave us and this is, God's word, but.
We have something that we probably have to clean up just because it's client specific, but we can share with you.
Because that would be helpful, I think, just to even get started on our own thing.
Yeah, no, we're happy to share it.
Okay, thank you.
Any other questions before we wrap up? Okay, for those of you who are still on, if you want to submit for HRCI or SHRM credits, you can do that for an hour and a half, not the hour and 45 minutes. So, please do that. And with that, hey, listen, both of you, Mike and Matt, I know this is a very unusual way for us to do an HR Connections meeting, but we made it through.
Made me clean up my office, which is a good thing.
Very good.
That's right. You didn't have to leave your office and come over the bridge, and we all got to stay in our offices and work while we were listening to you. But thank you so much for both of you for being
Yeah,
here.
thank you.
Our pleasure.
Thank you. And, we're going to see if we can figure out how to make this available, the recording available. And, we just, next week, we should be able to get something together and send a link out to everyone.
All right,
that
that
they-
sounds great. Thank you. Thank you, everyone.
Thank you.
Thank you.
Bye.
Bye.
Thanks.
See you. Bye.
Thanks, Mike.